Well, good afternoon, everybody, and welcome to the Samfiru Tumarkin Live Employment Law Show. We're on Facebook and YouTube. My name is Chen. I'm an employment lawyer with our firm's Vancouver office. We have offices in Toronto, Ottawa, and in Alberta as well. So my colleagues do these shows from other provinces as well, in case you're not from BC. But I will be here for the next half an hour or so. I'm going to answer questions live. So please, everybody, feel free to put your questions in. I can't see anybody, but I can see your questions on my screen in front of me here. Hopefully everybody can see and hear me okay. But please, any questions to do with employment law, with disability law, if you're having issues with some of your coworkers, if you're being bullied and harassed at work, if you've been part of these recent mass layoffs because the economy's taken a downturn, if you have issues of discrimination in the workplace, if you have a contract that's been presented to you, there's quite a big variety of well, at least from my perspective, a variety of issues that could happen at work. So please, anything and everything to do with employment law. I have a few topics I did want to talk about today, but I'm going to put priority to the questions. And I think we've got a few already here. Okay, so we've got our first question here from Kashin. Good afternoon to you too. You're asking, can an IME be performed at your place of work? The Manulife office is in the same building as the factory. So Kashin, that raises privacy issues, right? If you work, I assume at the factory, right? And the Manulife office where you're going to is the same place where people might see you. That raises privacy issues. There's no technical rule that says it can't be the same place, but there's certainly privacy concerns that you should talk to them about and see if you can do it somewhere else. But technically, there's not any legal rule I'm aware of where, just because they're in the same building, you can't have your IME there. But I would certainly raise that and ask for your concerns to be addressed and say that, look, I don't want any, because nobody has a right to your medical information at work, right? And if they see you going in there, that might raise questions. So definitely, get that concern addressed with Manulife and see if you can do it somewhere else. Yeah, I mean, especially if they're right door to door. I don't know the exact layout, but it sounds like if they're the same building, it sounds like there's a potential that your colleagues might see you. So we've got our second question here from JBK on YouTube. JBK is asking, can an employer choose what days you can book off for your vacation time? The short answer is technically yes, right? The employer has discretion to pick your vacation days. I know that each province has different rules so the employer can't just say to you, you got to take this day off, right? They've got to give you a block. I think in BC, I'm not sure if that's a hard rule in BC. I know in Ontario and other provinces, it's a 5-day block. So there's some nuances with that, JBK, but I mean, the short answer is yes, they can choose what vacation days. Well, a lot of companies don't, because that's not generally a good way to treat your employees by picking their vacation days for them. But certainly if in certain industries where if there's things to be done during a season and you can only take a vacation during a certain month, and there's schedules to work around, yeah, the employer can choose when you take your vacation. Well, I guess as a secondary to that, they can't choose not to give you vacation, right? You're entitled to vacation time, but they can choose when. And guys, everyone, if you have a follow-up question, if I haven't answered your question, if I have said something that's not clear and you want me to clarify, just put another question up there in the text box, and I'll get to it when I see it. So please feel free to follow up on anything I've said. We got our next question here from Sharon. Sharon's asking, can you be denied a request to take leave to take care of a sick family member? No. The answer is no. Each province has provision. I shouldn't say every province. I know for a fact BC, right? We have the Employment Standards Act, and under that act, you're entitled to time off to take care of your sick family member. Um, so, I mean, if they're denying your request, I would, consider letting them know of your right to that leave, the employer, I mean, and if it continues escalating, I would consider filing a complaint to the Employment Standards Board. Um, and if you're terminated because you decide to take the leave anyway, Sharon, there are certainly legal proceedings to try and address that, right? To remedy that, and there's potential you get your job back if you're let go. There's potential for lost wages. So you do have protection under BC legislation, Sharon. Okay, next question here. We've got a question from Saeed on YouTube. Saeed's asking, after voicing some health and safety concerns at our plant, you were let go with made-up reasons a few weeks later. Is there any way to fight this? Yeah, Saeed, absolutely. That raises actually probably a host of issues or things that the employer has probably done wrong. I mean, the first and most obvious is severance pay, right? You can fight for your severance pay, because this sounds like a situation where it's clearly not for cause, right? Which means you didn't do anything wrong, and they just decide to let you go on trumped up reasons, right? It's also arguably bad faith in that they're acting dishonestly, right? The company's acting dishonestly and they're lying to you, right? They're saying that this is the reason we're letting you go, right? Made up. But the real reason is because you raised health and safety concerns of the plant. So that's kind of the first way, right? And severance, if you've been with a company for a long time, it could be 2 years pay, right? If you're fairly senior in the company, it could be 24 months is about the maximum, but depending on other factors and how long you've been with the company, it could be a lot, or quite a significant amount. So that's the first way to fight it. The second way is through WorkSafe, right? You're raising a health and safety concern at work. You see something that's dangerous, or you see the company, whatever it is, right? You see the company not enforcing, hard hats when people should be wearing hard hats, whatever it is. You've raised that concern, right? And if that's the reason, right? If that's even part of the reason, so that's an important point, Saeed. So if it doesn't have to be the main reason, right? If that's even, let's say, whatever, 10% of their decision to let you go, that's probably a prohibited action under the WorkSafe Act in BC. And so if you can file a complaint, it's called a prohibited action complaint under WorkSafe. WorkSafe will investigate. The company will file a response, and you can get compensation through that proceeding as well, right? For lost wages, potentially you can get reinstated to your job through that prohibited action complaint that I was just referring to. If you're in BC, that's the answer. If you're in other provinces, there's similar WorkSafe legislation, I'm sure. So there are quite a few ways to fight that. Okay, we've got some more questions here. Got a question from Philip. You have medical accommodations since 2015, arthritis, modified work duties, micro breaks. They're outsourcing the disabilities to Sun Life, who does not do LTD. Employer says they don't allow. What can I do? So Philip, I'm going to need you to clarify a few things for me. What do you mean by they outsource the disability to Sun Life? So is Sun Life adjudicating some sort of disability claim? And you need to clarify the long-term disability part. So it sounds to me that, is it HR or Sun Life that's working with you through the accommodations? And are you getting benefits from Sun Life or the company, right? Um, and just clarify for me, Philip, you're saying the employer says they don't allow. What is the employer not allowing? Um, and maybe if you clarify that, I can try to answer your question better. If you've been on accommodations, right, since 2015, and you're working with those accommodations, and all of a sudden the employer saying we're not going to do those anymore. I mean, that sounds like a human rights complaint, a potential one, at least to me. um, every employer in BC has a duty to accommodate to the point of undue hardship, right? And that standard of undue hardship it's going to be different in every case for different size companies. It varies, right? It's not just one standard. um, the the thing I'd like to know from you is what's changed since 2015, right? If they've been accommodating you with these modified duties and these breaks, what has changed recently, and what is the company saying that they're not allowing you to do? Okay, so moving on to the next question here. C Dubs on YouTube. So you've got a few here. So you've been employed for 4 years, HVAC technician for 3 years before you accepted a transfer. No formal reason ever given. Um, Due to life circumstances, you accepted the change. Okay. As HVAC, you're entitled to take your work truck home 15 minutes every night after work. Truck and fuel company provided. When you were transferred to the new role, approximately 40 away from home, you were allowed to keep the truck and use it in company fuel to transport. Yesterday, your manager asked you to surrender the vehicle because the shop has a shortage of vehicle. You were asked to use your personal vehicle. I refused until I could seek advice. This is constant concern dismissal. Could I refuse? This seems like a benefit. I don't want to give it up. Curtis, so yeah. So Curtis, it's a really good question. There's actually, if my memory serves me right, there was a recent case very similar to yours. The name of it is slipping my mind, but certainly, you can feel free to contact me afterwards. But there's a recent case, I think it's from BC, or it might be actually from Ontario, where something similar happened, where someone's work vehicle is taken away. And I believe that the finding was actually that there was a constructive dismissal. It's not exactly like yours, Curtis. I wouldn't take that as I wouldn't take that as yes, yours is a constructive dismissal. It's always a question of degree, right? So in this other case, I think it was the value of that vehicle and the gas and everything was actually worth a lot. That's the question in your case, right? But feel free to reach out to me. The name of the case is slipping my mind, but I think the two questions when you reach out to me that I'm going to ask you is, is there something in writing in your contract about the vehicle? Email doesn't have to be a contract. It can be emails with your boss, with anybody else at the company, because you're right, it is a benefit, right? Even if it's not in writing, it could be a verbal agreement, right? That's just as legally binding, hard to prove, but just as legally binding. If it's a verbal agreement, it is a benefit. It's a condition of your employment, right? It's a term of your employment. If they're taking it away, that's potentially a constructive dismissal case. And so I need you to calculate. I'm going to ask you that. Or if you're in Ontario or any other province, talk to a lawyer about this, obviously. But I think they'll ask you that. They're also going to ask you what's the value of the truck and the gas, right? Like how much of a pay cut is that for you? And you're absolutely right. This is something you don't necessarily have to accept. Okay. After you speak with a lawyer, depending on how big the monetary loss is to you, you could reject the change, right? You could say no. You have to give me the truck, right? You don't accept this change. And then the second step would be a potential constructive dismissal for severance pay, right? And so if you've been there, 4 years, the severance, it'll be at, it's hard to say in your case, but it'll be more than a few weeks, I imagine, because the minimums in BC for 4 years is 4 weeks pay. And usually common law, you get a lot more. So I think, those questions I raised, you need to talk to a lawyer about. All I can say on here is there's a similar case to yours where I'm pretty sure the judge found in favor of the employee. So you definitely have a case, but as with any constructive dismissal case, you always get legal advice before you do anything that obviously affects your life, right? It's your job. So I'm hesitating to give you an answer on here because it takes way more time and analysis. But there is certainly something there. Okay, so moving on, moving back to Phil. So Phil, you're dealing with Sun Life and the accommodations. You're saying Sun Life takes the files. You're not off work with modified duties. Employer says they do not allow LTD, and I have been having to resubmit my forms every year at my cost. I see. Every year, they want to know, I'm assuming the employer, if your condition has improved. And you have to get doctor's notes. So Philip, I think it sounds to me that you're off work, but you're not off work. You're working with modified duties, but you keep having to submit doctor's notes because they want updates on your medical condition, I assume. And you're still gonna have to clarify where Sun Life comes into this. Employers generally, well, I'll say, generally, they want people back at work 100%, right? That's why they're asking you for the updates, every 6 months or every year or whatever. Just tell me about what Sun Life's involvement in this is. Are they the third party that's helping coordinate your modified duties and looking at the medical documentation? To some extent, the company is entitled to updates to your medical information, right? Not your diagnosis or anything like that, right? You don't have to tell them what conditions you have. They're more entitled to information like, what are your restrictions, right? Lifting restrictions, walking restrictions, and what's your prognosis, right? Like how long is this going to last? So they're entitled to some information, but not a lot of other private medical information. So Phil, you're still gonna have to clarify your question for me because I'm still, and I apologize, I don't understand what you're asking. Okay, we got a question here from Jim. Jim, you're from Ontario. You have to bring a lawsuit within 2 years. You were denied short term on November 30th, denied long term on March of this year. On the employment disability show, employers are entitled to prognosis, not the diagnosis. What law is this? If your employer had issues with you being on LTD and a lawsuit against your employers to go to the court, what happens to your personal medical information? The medical information would have to be shared as evidence. Is your personal? So Jim, I guess I'll try to answer your question in the order you raised them. So let's go back to your first question. So you have to do 2 years. You were denied short term on November 30th. When you got that letter from the insurance company saying that your disability, short term or long term, right? But it sounds to me like you got on November 30th, 2021. Okay. If you got that letter on that date and you that's when you discovered that your claim was denied, that's when the 2 years starts. So you have some time, it sounds like, right? You have until, well, I guess 2 years from November 30th, 2021. and that's for your short term, right? So your long term would be later if it was denied at a later date. But I would use that first date, Jim. You use the earliest date you found out that your claim for disability benefits was getting denied. The second part of your question, Jim, employers are entitled to prognosis, not the what law is this? So, Jim, a lot of our laws are not written down in some piece of legislation passed by Parliament, right, or by the provincial legislature. A lot of it is common law, which is it's judge-made law, right? And so there's been I can give you a number, hundreds, thousands of cases that have obviously been unemployment cases I'm talking about that have been before a judge. That's where the rules develop, right? And the general rule we see from judge-made law is that generally employers can't ask for the diagnosis, but generally, again, they can ask for the prognosis because they would like to know, how long your condition is going to last for, to see if they can accommodate you and plan their operations accordingly, right? It's information that they might need to plan their business around. So if you're going to be restricted for 2 years, for example, they might hire someone temporarily to help you or cover some jobs that you're unable to do. So the third part of your question, if your employer had issues with you being on long-term disability and a lawsuit against your employer was to go to court, what happens to your personal medical information? So, and the second part of that, Jim, you're saying the medical information will not be treated as evidence. Is your personal information, medical information, get redacted to only show the prognosis? So, Jim, there's several different scenarios I see here where it really depends on what happens or what happens in your or let me rephrase that. Sometimes your employer pays the long-term disability benefits. A lot of times it's the insurance company paying it, right? So to your first question, it depends on who you're suing and what you're suing them for. If you're suing the insurance company for long-term disability benefits, the insurance company gets all of your personal medical info and it's not redacted. But the insurance company can't go and tell that personal medical information to your employer. Okay, so it's protected that way. Another example, if you're suing your employer for wrongful dismissal because they've terminated you, then I can see why in that case the employer would probably be entitled, depending on the issues, but they probably be entitled to see your personal medical information, and it's not redacted. If you're suing the employer for anything that brings your medical condition into issue, they're gonna probably be entitled to that information. In your case, I mean, it sounds like unless the employer is the one paying the benefits, it sounds like you'll be okay because you're suing the insurance company who's under an obligation not to give any private medical information to the employer. So Jim, hopefully that answers your questions there, but feel free to follow up if I can clarify anything. So Curtis, do you have an email to share? Yeah, you can go to help@employmentlawyer.ca or go to employmentlawyers.ca. My email is actually on the website. So mine is just sandy.chen@stlawyers.ca. But it's on our website. You're saying the agreement was verbal. We can talk about that, Curtis, because it's a matter of proving it, right? So, we can talk more about that. Okay, we got some follow-ups here from Phil. So Phil, you're dealing with medical accommodations. They're interviewing you about how the arthritis affects your ability to do your job. They approve accommodation, but it's usually 8 to 12 months. I even had 1 year they only approved 6 weeks, and you have to go through the whole process again. Yet they still making me go through this. I have to speak. So Sun Life says they do not do LTD cases, saying I have to speak to my employer. An employer says they do not allow LTD. Well, I think, Phil, my view is, your employer saying that is does not seem right to me. Okay, Sun Life is probably, well, I assume they're the insurance company, and they're saying to you, Phil, you can work, so we're not going to pay you benefits, right? Because you can work with accommodations. Okay, the employer, if they're saying they're not allowing you to work with accommodations, that sounds, well, that could be a potential human rights complaint, right? Because they have to accommodate you to the point of undue hardship, and they're entitled, let's say, once a year, to check up, like they can check up on you, right, on the accommodation. They can do a medical assessment if they want, right? 6 weeks seems a bit short. That seems like it's unreasonable. If it's once a year, I think that's probably okay. If it's once every 6 weeks, that's way too much. But if they're now saying to you, we're not going to allow these accommodations, we're not going to allow long-term disability, that seems like a discrimination issue. So, yeah, I mean, so I guess my answer to you is, if they're not accommodating you, you have a complaint to the Human Rights Tribunal. I knew it sounds like not a great spot to be in, because I know Sun Life's probably saying to you, we're not going to pay you benefits, and the employer is probably saying to you, well, we're not going to accommodate you or give you long-term disability benefits, but you do have protections, Philip. So feel free to come talk to me more about it after, because I think if the issue is they're just checking up on you once a year, that's probably okay. But as I said, every 6 weeks is excessive. Sounds excessive to me. Okay, we got our question here from Monica. Your manager wants to enforce your work. 8 to 5, 1 hour lunch. In case I wish to only take 30-minute breaks so I can leave earlier, can he enforce me to take 1 hour instead? Yeah, Monica, this is it's a good question. It's a question that really depends on a lot of things I don't know about your situation. What your employment contract says, right? Are you union? If you're unionized, your collective agreement, well, your union rep should be able to tell you, right? I assume you're non-unionized. If your contract says 8 to 5 with a 1 hour lunch, then yes, they can enforce those hours of work, right? I've seen companies with flexible, policies like that, where they say, if you want to, leave early, you can make up the time later or take a shorter lunch. If that's a policy of your company, then obviously that's something that's binding, right? It binds the company. If they have a policy like that and you want to use it, you should have access to it to leave 30 minutes early. But if it's just your contract says 8 to 5, 1 hour lunch, you might be out of luck, unfortunately. Okay, guys. So I think, one last question here from Tim Miller. Do you practice? I do not practice in California, unfortunately. Just BC, Timothy. So guys, I think that's all the time we have today for questions. I will be back in 2 weeks. And if I've missed anybody, I believe my colleague Dan is on tomorrow. Actually, no, maybe not tomorrow. One of my colleagues, Dan or Dan, will be back early next week or tomorrow. I will be back in 2 weeks, but yeah, thanks everybody for tuning in, and I'll see everybody again in 2 weeks.